Okay, hello. Hello, everybody. Let me get myself sorted out here. Happy Sunday. Yes, we made it to Sunday, which means it's the eve of a new week. Yay. Oh my goodness, last week was just a lot. Hopefully, this next week won't be as much. Fingers crossed. We shall see how that goes. Hopefully, we'll have some good things happen. But I'm not going to hold my breath. Hello, Terry. Hello, Kathy, Boxer Mom, Donna, good to see you. Ellen, Sylvia, hello. Sarah, welcome. Green Lady, hi, Kaya. Just do it. Hello, welcome in. Willie B, hello, Heather. Violet is blue. It is. It is. Oh my goodness. Well, welcome in, everybody. Oh my goodness. I was a little late getting us going here, but that's all right. I really hope 2 lawyers in contempt requesting SCOTUS. What's the chances? Nah, we'll see. I don't know. I think everything's on the table right now. Anything's possible. Absolutely anything's possible. And tonight I do want to go and go through the Abrego Garcia situation here. I was over on the TikTok. When was it? I can't remember. Was it Thursday? I think it was Thursday actually, because we had some breaking news out of the courts with regards to the Supreme Court. So we had some breaking news there. Since the breaking news, everybody, we've had a couple of other filings. First, we had a filing from the district court. She, after the Supreme Court ruled, she did give us some clarification as they had requested. So that's document 61. And then we have plaintiff's motion for additional relief, which I think is actually very helpful because they set out some of the things that the court could do. So I want to go through that. That's document 62. And then we have this declaration by Michael Kozak that was on the 12th. And then today we've had 2 filings, declaration from Evan Katz, and then we have the defendant's response to the plaintiff's request for additional relief. All right, so we've got all the pieces that have happened that have been filed since the Supreme Court order that came down, the per curiam. So we can go through all of those things. Yay. Yeah, we've got some weird stuff going on. Can everybody see the document okay, or do you need me to zoom in a little bit? Are we okay? Just double checking. I have a question. I need help. I have a warrant. Okay. Are you, zoom in please. Okay, are you over on TikTok also, or are you just here? I do have my DMs open on TikTok, so you can always send me a message there. I do not represent anybody, though, on any of my social media, so if it's an academic question, I can help you, but if it's a personal case question, I do not, ethically, it goes against our ethics rules to do that, so apologies. Okay, yeah. So we can see it better now, everyone. Here we go. Make a messy dinner. Oh, we love that. Messy dinners are the best dinners. All right, here we go. Hello, Achilles. Hello. Hello. So we are just going to go through the paperwork that's been filed here since the Supreme Court decision came out. What are we thinking about a sticky note, everybody? I'm gonna kind of poll the chat. Would we like a sticky note to explain that this is a thank you. Thank you, Sarah. That this is the Garcia case. Is that helpful, or do you think we're okay? Is it self-explanatory, or do we need a sticky note? Just let me know. Sometimes I just don't know which ways. Yikes, I know, Sarah. Oh my gosh, everybody. Sometimes you got to let the trolls into play for a little bit so that, we can make sure everybody can see the live. But then on the other hand, yeah, it escalated quickly. On the other hand, there's trolls and then there's actual, like, scary stuff. Oh my gosh. Yes, yes, yes. No, no, not Violet. That's funny. No, I'm not conserving sticky notes. That's so funny. Actually, I just got a new shipment in. I'm so excited, everybody. I'm so, I'm extremely excited about that. I have these new, oh my gosh, everyone. Let me just brag for a minute before I dive into the documents. So I found these new sticky note memo holders. So these are actually next to my computer, and I've got different categories. And this one's the one where I can take my sticky notes like on and off the docket. And then, like, these are the Trump cases that are his civil lawsuits still going and stuff. Can you believe it? I'm bragging. I know I'm bragging, but I was like, what's this thing that you're showing me that's been invented? I'll take that. So yes, I do love my sticky notes. They have become part of my life and my family's life now, as various cats get them stuck on their fur. Oh my goodness! So that's a lot of fun. We love that. All right, so oh my gosh, I tell you, my OCD as well. My OCD has been like, oh, maybe I'll let you sleep tonight. Maybe I won't. We'll see. All right, let's go ahead, put our sticky note up here, just so everyone knows the case when they start hopping on. I know that's the first question everybody asks when they come on and see a document. They're like, what case is it? And then everybody says it over and over and over again. So it's just easier, I think, to, sorry about that. Easier to just have a sticky note. But here we go. Abrego Garcia. I've just been calling him Mr. Garcia, but of course that is not quite right. 36,000 in LA. Love that. Love it. Okay. And then we know I'm here. Yeah, this case, everybody, this is it. I mean, this is absolutely crazy, this particular case. So as we watch all of this mess unfold historically, more space for sticky notes than I know. I do. It's true. It's true. I have an probably unhealthy amount of sticky notes. Oh, that's important. It's great to keep yourself busy. It's great. Extendable pointer with a hand that looks like Mickey. Oh my gosh. Oh, yes, yes. Yeah. I've been thinking about that too. I'm like, should I get one of my Harry Potter ones out? But I don't know. It's just, we're having a good time. We're having a good time. All right, so here we go, everyone. I will be doing an overview of the closet docket the next time I come on here on the tube. But because we did have filings today and we're continuing to have filings every day, I will probably just keep posting the updates here. So let's take a look. We all know, just to catch everybody up, this is the case where Mr. Garcia was wrongfully taken to El Salvador, and the government had admitted that it was a problem, that there was an administrative error. So we have an admission. None of the other cases do we have just a clear understanding and admission that the administration screwed up. But we do for this case, and this case went all the way up to the U.S. Supreme Court because our district judge here said you need to go and get him and bring him back. They appealed that. So the Supreme Court said, yeah, you're going to need to follow the order. The judge was right. So with that, we've now got an order on file from the Supreme Court supporting our district judge here. One of the things the Supreme Court mentioned in their per curiam unanimous decision was they had asked the district court judge to clarify a couple of things. Now, I always say her name incorrectly, but let's try to work on it. Is it Zini? Is that right? My Mandarin studies are screaming at me that that's incorrect. But what do we think? How do we say her last name, everyone? I need a hand. I need help. Is it Zini or Chinas? Chinas? Is that right? Zinus. Okay, Zinus. All right, all right. I was Zinus. Okay, Zinus. Okay, yeah. Where's Daisy? Where's Daisy? Come on. All right, I'll do my best. So Judge Zinus is the one that did the original order, right? So she read the per curiam and was like, sure, let's clear it up. Let's clear it up. So that's where we'll start tonight with the judge's clarification based off of what the Supreme Court said. So here we go, everyone. This is by Judge Zinus here. For reasons discussed during today's status conference, the court finds the defendants have failed to comply with this court's order. In advance of the conference, the court had directed defendants to file a supplemental declaration from an individual with personal knowledge addressing the following. So this is really going down that same road as the JGG case, everybody. This is just very similar, where we have in JGG, the Chief Justice in DC is the judge presiding there. And he was saying, look, I've got questions, you need to answer them. So we're absolutely we're partnering basically with that same kind of situation. Number one, the current physical location and custodial status of Abrego Garcia. Spoiler, no one knows. Two, I mean, I guess they did. Hold on, everybody. I did do 2 declarations, and they did say he was in the facility in their custody. But number 2, what steps, if any, defendants have taken to facilitate Abrego Garcia's immediate return to the United States? And 3, what additional steps defendants will take and when to facilitate his return? Defendants made no meaningful effort to comply. Instead, they complained that the order is unreasonable and impracticable and involves sensitive country-specific considerations wholly inappropriate for judicial review. During the hearing, the court posed straightforward questions. This court sounds mad right now, everybody. This is this is an angry judge. All right, check my mic. Is my mic okay, everybody? Can we hear? Hold on. How about now? Can you hear me okay? Can you hear me now? Just making sure. Is it scratchy or is it echoing? Aren't going to fall court. Well, you just never know at this point. Okay, it's good. Is it good? Okay, okay. Excellent. Thank you so much. So this judge is getting frustrated. It's crackly. Okay, well, getting some static. Static. Oh, shoot, everybody. Okay, we're good, and then we have some static. Well, I'll do my best. I did just get a new microphone here, but I don't have it hooked up yet. So I'll do my best. A tiny crackle. Okay, well, I'll do my best here. Let me see if I can. And we'll just try to get through this, and then I'll have it set up for next time. Apologies, everybody. All right, here we go. During the hearing, the court posed straightforward questions, including, where is Abrego Garcia right now? What steps had the defendant taken to facilitate his return while the court's initial order on injunctive relief was in effect from the afternoon of April 4th of 2025 through the morning of April 7th of 2025 and since 6:35 p.m. last night? Defendant's counsel responded that he could not answer these questions and at times suggested the defendants had withheld such information from him. As a result, counsel could not confirm and thus did not advance any evidence that defendants had done anything to facilitate Abrego Garcia's return. This remained defendants' position even after this court reminded them that the Supreme Court of the United States expressly affirmed this court's authority to require the government facilitate Abrego Garcia's return. It's a little crackle. How is it? It's fine for me. A little crackle here and there. All right. I do have one more mic. I do have my headphone mic we could try. Let's just try it here and see. Because sometimes with the headphone mics, the crackling is actually worse. But let me see if we can try it here. Okay, everybody, we'll give it a go. We'll give it a go. We'll see how it goes. Hello, welcome, Tay. All right, what do we think? How is it? Can you guys hear me? Guys and gals and pals? Is it better? Is it better or worse? Plugged in all the way. Okay. There we go. There we go. Is it better? Can you hear me? Not as good. Okay. Worse. Oh. Ah! Turn up the volume. You sound very far away. Okay. All right, I'll try one more time and then we'll just no crackle, but the volume was worse. Okay, here we go. Let's see. I'm so thankful for all of you working with me since I don't know how any of this stuff works. How's this? How's this? Is this working better? Try the new mic. You just need to plug it into your... Sounds fine. Okay, how is it now? Wait, hold on. I've got a bit of a delay. Are we good now? Now is good. Okay, great. Okay, excellent. Better, better, better. Good. Okay, still a little quiet. All right, let me bump it up a little bit more. Okay, maybe that. Is that better? Ooh, it's worse. It's perfect. All right, are we good or should we go back to number one? Should we do number one or we're good? We're good. Better, better. Okay. I don't know, everybody. We'll give this a go. We'll try to make it through here. Better now. Okay, sounds great. Okay, excellent. All right, here we go. I'm diving back in. Here we go. From this court's perspective, defendants' contention that they cannot answer these basic questions, absent some non-specific vetting that has yet to take place, provides no basis for their lack of compliance. Accordingly, it's hereby ordered that beginning April 12th and continuing each day thereafter until further order of the court, defendant shall file daily on or before 5 p.m. Eastern a declaration made by an individual with personal knowledge as to any information regarding 1. The current physical location and custodial status of Abrego Garcia. 2. What steps, if any, defendants have taken to facilitate his immediate return to the United States. 3. What additional steps defendants will take and when to facilitate his return. And footnote 1 says, defendant's assertion that foreign affairs cannot operate on judicial timeline sorely misses the point. Ooh, rude. All parties appearing before this court are obligated to comply with court-ordered deadlines unless and until they demonstrate good cause to depart from them, which every attorney knows. Defendant's vague reference to foreign affairs alone does not justify their lack of compliance, right? A follow-up in-person hearing will be scheduled for Tuesday, April 15th at 4 p.m. To the extent plaintiffs seek additional relief, their motion shall be filed no later than 5 p.m. Eastern on Saturday. Defendant shall file any response by 5 p.m. Eastern on Sunday, April 13th. All right, so that was her response then, everyone. The judge's response. And again, we do have, just making sure I'm centered here. We do have 2 declarations that have been done along with the defendant's response for the special request. So that's our first one. Again, let me know if the microphone starts sounding weird. I'm just holding it, so if I brush it against something, it might crackle a bit. So just let me know. But here we go. Next one, we've got. I thought this was actually really interesting. The plaintiff's motion for additional relief. They went in and said, hey, here's some things you can do. Actually telling the defendants, like, we feel like you may not know what you can do, so we're gonna just give you some ideas. And I love that. So this was filed shortly after that. Plaintiff's motion for additional relief. So again, this is being filed by the plaintiffs. Yesterday, President Trump confirmed that the United States has the power to facilitate Abrego Garcia's release from prison and return to the United States. Quote, if the Supreme Court said bring somebody back, I would do that. I respect the Supreme Court, end quote. And then footnote 1. It's always great when we have direct quotes, isn't it, to support our position. So this is taken from a New York Times clip. Of course, that is precisely what the Supreme Court did when it ruled that this court's injunction properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. We have a citation here. The government should be required to comply with the Supreme Court's order that it ensure that his case is handled as it would have been had he not improperly been sent to El Salvador by taking all available steps to release and return Abrego Garcia to Maryland. The president's acknowledgement of the United States' power to bring Abrego Garcia back, notwithstanding the Department of Justice and other government agencies continue to resist this. Oh, thank you so much, Violet. I appreciate that. Oh, that's so sweet of you. Oh my gosh, this case is incredibly important. And, I'll be able to do daily updates until we see movement on it. Court in the Supreme Court. At yesterday's hearing, the government defied an order of this court and of the Supreme Court by refusing to provide even basic information about Abrego Garcia's current location, and which is, again, the same thing going on in the JGG case, and status and what it is doing to comply with the injunction. Here at 1, directing government to be prepared to share what it can concerning the steps it's taken and the prospect of further steps. Ordering government to submit a declaration addressing 3 questions. Order finding the defendants have failed to comply with the court's order here. As a direct consequence of the government's recalcitrance, Abrego Garcia continues to suffer irreparable harm from his illegal removal to a country where he faces persecution and violence and where he's being held at the United States' behest. So next, in accordance with the court's order authorizing plaintiffs to seek additional relief beyond what this court previously ordered, plaintiffs request that the court order 3 additional types of relief. So this is really great because they're literally walking them down the road. They're like, this is what you need to do. Let's just walk down the road. First, order the government to take by end of the day, Monday, April 14th, 2020, whatever, the specific steps set forth below to comply with the injunction in the case. Second, order expedited discovery of the government's action or failure to act to facilitate Abrego Garcia's return to the United States. And third, order the government to show cause by 10 a.m. Monday, April 14th as to why it should not be held in contempt due to its failure to comply with the court's prior orders, including any failure to comply with the court's order of April 11th. So this is what they're requesting here. This is what the plaintiffs are saying we can do. So next up, they go through the applicable law, and I'm not going to spend too much time on that at this point because we do have a lot of things to go through. So they're setting out why they can request discovery, why they can make these requests. So number 2, the relief that is requested here. Plaintiffs request that the court order the following relief to ensure compliance with the prior order. We're on page 4. So facilitation of Abrego Garcia's return. The court should order the government to take the following specific steps in addition to whatever other steps are within its power to facilitate Abrego Garcia's release from custody in El Salvador and return to the United States. So number 1, request that its agents and contractors release Abrego Garcia from custody in El Salvador pursuant to the contract or arrangement providing for his detention there at the government's direction. So this is really important, everybody. This is what the judge brought up in her original order, is that there's got to be some kind of a contract between the U.S. and El Salvador. Nobody knows what those terms are, but there's got to be some understanding, because the way she put it was it wasn't, like some kind of a lifetime situation, like they were given lifetime sentences in this place. It was the span of a year. That's one thing too, is that, I don't know El Salvador's rules, but I mean, again, a life sentence requires a lot of money to keep people there. So I'm not sure the $6 million is going to be enough money for lifetime holdings of these people. So I think that that's really the key, is what does the contract say? But we don't know, because the government won't share that. Pursuant to the contract or arrangement providing for his detention there at the government's direction, the record reflects defendants have outsourced part of the United States' prison system. And just as any other contract facility, defendants can and do maintain the power to secure and transport their detainees, Abrego Garcia included. Dispatch personnel to accompany Abrego Garcia upon his release from the facility to ensure his safe passage to the aircraft that will return him to the United States. 3, provide air transportation for Abrego Garcia to return to Maryland, because he may not be in a current position or in current possession of sufficient identification to board a commercial flight. Number 4, grant Abrego Garcia parole pursuant to the Immigration and Nationality Act, and prepare all paperwork and forms required to allow him to re-enter the United States. All right, so I think those are pretty clear requests. And here's B, expedited discovery. So expedited discovery, of course, is one of the key pieces, because we're not getting any information from the government. The only way we've gotten anything from the government is if it's being court ordered through this process. Plaintiffs request that the court order the following expedited discovery. The government should be ordered to immediately produce contemporaneously prepared documents in such form as they existed at the time of Abrego Garcia's removal, sufficient to reflect the terms of any agreement, arrangement, or understanding regarding the government's use of that facility to house U.S. deportees. So they're saying, what's the contract? What did you people agree to, is what they're asking for. And they're saying, you need to tell us that right now, which is the expedited piece of it. To the extent the government contends that such documents do not exist, it should be ordered to produce a witness for Tuesday's hearing who can testify from personal knowledge about the terms of the arrangement. That's fantastic as well. Same with JGG. They're like, if you're not going to tell us, somebody needs to come in, sit down, be sworn in, and be asked questions. And then they would be subject to cross-examination as well. So footnote number 2 says the government's not asserted, let alone properly substantiated, any privilege that would allow it to withhold the information sought, and plaintiffs are aware of none. So that's really important. The government should be ordered to produce witnesses for Tuesday's hearings from the Department of Homeland Security, Department of Justice, Department of State, who can testify from personal knowledge, which is required for any witness, about 1, Abrego Garcia's current physical location, custodial status; 2, what steps, if any, the government has taken to facilitate his return to the United States; and 3, whether the government has informed officials at the facility that it wishes Abrego Garcia to be released to U.S. custody. That's a really good question. Have they even asked? Has the government even asked El Salvador? Can they? Oh my gosh. Oh, thank you so much, Linda. Well, that was really cool. Have they even asked about it? I think that's a valid question. And 4, what, if any, additional steps the government intends to take and when to facilitate Abrego Garcia's return? And then they're citing to the hearing this case that involves 3 different cabinet departments. So that was another piece set out. Order to show cause. And again, as we know, the order to show cause is basically saying there was noncompliance with a court order. This court's already found the defendants have failed to comply with this court's order because they did not provide the required declaration. The government's failure to provide that declaration also calls into question whether the government's complying with the court order granting preliminary injunction as modified. Defendants accordingly request that the court order the government to show cause why it should not be held in contempt for failing to comply with this court's orders in accordance with its inherent authority. So they're asking again for contempt. They're saying, hey, you guys need to come in and explain that you did not violate the court order after the judge has already said that they did. Here's our conclusion, everyone. Again, for the district court level filing by the plaintiffs. For the foregoing reasons, plaintiffs request that the court, 1, order the government to take by end of day Monday, April 14th, the specific steps set forth above to comply with the injunction in this case. 2, order expedited discovery as set forth. And 3, order the government to show cause by 10 a.m. Monday, April 14th, why it should not be held in contempt due to its failure to comply with the court's prior orders. List of people, and I really want to know why they are keeping the list of. Yeah, I mean, the government's refusing to. I apologize, everyone. I bet I'm moving my mic around here a little too much, but the government's refusing to help in any way, to give any information about anything going on with any of these flights. And so they're refusing to share, and they're refusing to share the contract. Anything that's happening in this case is going to have an effect on the JGG case. So we have a couple of cases where it's going to be affected, and they're just unwilling. They're just saying, well, it's foreign relations, so we don't have to tell you. Meanwhile, it's getting fought again with the Chief Justice in DC saying that, that's not it. So, yeah. All right, that's the petitioner's request. So let's move on. And we have 2 declarations in case you have missed my posts. I have posted on both of the people who have made their declarations here. And again, they're supposed to file something each day. And so the first one here is by Michael Kozak. Yeah, I'll just read through this. It's absolutely not in compliance with what the request is. And you can see how they're trying to continue to evade what's going on. But yes. Yeah, I mean, yeah. Here we go. I am a senior bureau official in the Bureau of the Western Hemisphere Affairs, United States Department of State. As senior bureau official, I'm a member of the Senior Executive Service responsible for, among other things, coordination of the conduct of our diplomatic activities in the countries of Western Hemisphere. Before that, I was senior coordinator for Afghan refugees in the Bureau of Population, Refugees, and Migration of the United States Department of State, and have held various other roles in the Department of State since 1971. I'm aware that the instant lawsuit has been filed seeking the return of Kilmar Abrego Garcia to the United States from El Salvador. I provide this declaration based on my personal knowledge, reasonable inquiry, and information obtained from other State Department employees, which of course is just all hearsay, right? Anything that's not just his personal knowledge, or anything his personal knowledge is based off of because of hearsay, is just all hearsay. So which, that's fine, but it's important to acknowledge that we don't have evidentiary rules in play for these declarations. And again, the reason I bring it up is because we have a trustworthiness issue going on. It's my understanding, based on official reporting from our embassy in San Salvador, that Abrego Garcia is currently being held in the confinement center. He is alive and secure in that facility. He's detained pursuant to the Sovereign Domestic Authority of El Salvador. And then he signed it. So there we go. All right, and then we have the declaration that was just filed today, everyone. And then after this declaration, we can get into the defendant's response as to, what the plaintiffs had requested. So Evan Katz, I'm an assistant director for the removal division within the Department of Homeland Security, U.S. Immigration and Customs Enforcement, and Enforcement and Removal Operations, ERO. Is it ERO or ERO? I always just want to say the letters rather than, make a name for it. But I'm gonna just say it's ERO rather than ERO because that's just weird. But whatever, forgive me. In this capacity, I'm responsible for leading the division, which is composed of ICE air operations, international operations, and removal management. I coordinate with the 25 ERO field offices to support case management and facilitate, oh good, I'm glad I'm not alone, woohoo! And facilitate the removal of aliens from the United States. I have held this position since December of 2023. Before this assignment, I served as acting assistant director for the removal division from January 2023 to November of 2023, and deputy assistant director for the removal division from January 2015 to December of 2022. I have been in service with ICE since 2003, and prior to that, the Legacy Immigration and Naturalization Service since November of 1997. All right. So, um, I guess since the late 1900s. Ouch, it always hurts to say that. I provide this declaration based on my personal knowledge, reasonable inquiry, and information obtained from various records, systems, databases of the Department of Homeland Security employees, information portals maintained and relied upon by DHS in the regular course of business. Again, hearsay, right? We don't have any evidentiary requirements here, so it's just based off of what he's gathering. I'm aware that the instant lawsuit's been filed regarding the removal of Kilmore Armando Abrego Garcia to El Salvador. I'm aware that after this court's preliminary injunction issued, that the government sought a stay pending appeal from the Fourth Circuit on the same day and ultimately the Supreme Court. On March 7th, Chief Justice Roberts issued an administrative stay of that preliminary injunction order. On March 10th, the Supreme Court held the deadline in the challenged order is no longer effective. And that aspects of this court's injunction needed to be clarified before they could become effective. So this kind of messes me up a little bit, everybody, right? So I mean, I'm confused. The government sought a stay pending appeal from the Fourth Circuit. On that same day, ultimately, the Supreme Court so issued an administrative stay of that preliminary injunction order. So we've got March 7th and March 10th, but this whole situation occurred like on March 15th through March 17th, didn't it? I mean, right? I mean, am I crazy? Is that, well, I mean, about this, they're saying on the 7th there was this stay issue, and then on the 18th there was this order, but those were weeks before. Oh, we got the month wrong. Okay. Thanks for helping me with that. Because I was like, dude, this is your declaration. You're saying everything in here is true. All right, so we'll just put April in there. Thank you so much. I kept thinking, like, well, that's not logical. All right, next, the Supreme Court held that the deadline in the challenged order is no longer effective because that date had already passed. That's why it wasn't effective. And the aspects of this court's injunction needed to be clarified before they could become effective. So he asked the lower court to clarify what effectuate meant. So next, during proceedings in 2019, I mean, this would be, for me, this would be a 401 objection if we were actually in court, because this is not relevant. During proceedings in 2019, an immigration judge upheld DHS's decision not to grant bond, finding that DHS's determination that he was a member of this gang was trustworthy and supported by other evidence, and noted that Garcia failed to present evidence to rebut that assertion. The Board of Immigration Appeals upheld the finding when Garcia appealed. All of this is questionable information. First, it's not relevant. Second of all, is incredibly questionable. We don't know who this person is. None of this information is actually properly cited. Like, you're pulling quotes, but you're not even giving us the citation, right? So anytime that happens, it's always suspicious because it's always sounding like someone's telling somebody who's telling somebody. So for example, here, the determination he was a member of the gang was trustworthy and supported by other evidence. Where's my citation, right? Where's the citation? Was that in an order? Which order was it in? And noted that he, quote, failed to present evidence to rebut the assertion. Well, where's that? I mean, where in the record is that citation? And again, the appeals upheld the finding when he appealed. Again, no citation. So this whole paragraph is suspicious because we don't have any confirmation. And that's what's so weird here is that these people that are working in a law enforcement capacity don't understand just the basics of what is needed for evidence. If we just walk away from this case and we just look back, look at these people here he's been working in this job since 1997, and he doesn't know how to cite evidence. Like, that's really troublesome, right? It's really worrisome. And right, so this is just unacceptable, absolutely unacceptable. And again, maybe because during my prosecutor days when law enforcement did this, I would just have to rip them a new one. But, ICE is coming in here saying, well, he's going to be part of it. It's like, well, I don't have any proof. And you didn't even give me any proof other than what you're just talking about here. How am I supposed to believe you? We object. Lack of foundation, lack of authentication, lack of relevance. I mean, there's like 10 different rules that you can object with. All right, next on, moving on. I got a little angry here. Sorry about that. Here we go, moving on. On March 15th, Abrego Garcia, native and citizen of El Salvador, was removed to El Salvador pursuant to Title 8 of the United States Code. So this is important to remember as well, everyone, because Abrego Garcia here, we got to make sure that we're following how it was that they are justifying the removal, right? Although Garcia has an order of removal issued by an immigration judge, I understand. And when you put I understand in, it means that you're acknowledging you could be wrong. I understand that he should not have been removed to El Salvador because the immigration judge had also granted Garcia withholding of removal to El Salvador. So first we have an admission, but it's what I would call like a sloppy or a loose admission. I don't know these terms, everybody. You're probably like, that's too much information. That's what we call that because it's a qualifier here, right? He's not saying, well, yeah, he shouldn't have been moved. No, it's like, well, my understanding, like if you only have an understanding of what's going on, why are you writing a declaration to the court? You know what I mean? All right. However, I also understand that Garcia is no longer, and this is where things start to get really hinky, eligible for withholding of removal because of his membership with that bad people group, which is now a designated foreign terrorist organization. So this, again, his understanding, he's basically saying, well, I'm now the judge. I'm now an immigration judge. And I'm saying, based off of my understanding, that the federal statutes involving immigration and terrorism and executive orders, based off of my extensive knowledge of the law, that he now should have the prior court order vacated. I'm just going to go ahead and vacate that. This Evan guy is like, what? Who? You're just going to go ahead and overrule a judge. That's a lot of power that Mr. Evan here has. So that's very frustrating. And I've revised the declaration. I've reviewed the declaration of Mr. Kozak, which was filed in this case yesterday. It's my understanding, again, that defendants have no updates for the courts beyond what was provided yesterday, which again is a violation of that court order. She's saying, dude, tell me what y'all are doing. And he's like, well, the only thing we did today was I wrote this piece of crap and filed it. So that was the update on that guy. The aliens act due to the fact that we're not at war. Well, they will. They will. The thing is, everything has an order. We have to go in certain steps. We have to have the right order of things. So, of course, that's a huge issue. And actually, the very first, what I see for the very first hearing to actually have this issue of the Alien Enemies Act argued is in a habeas case. And I can't remember which one it is, but it's set for like mid-May because one of the people who was, sent to the El Salvador, a different one than any of the people that we know here, is saying, look, this is a wartime act and I'm being incorrectly or unlawfully detained, and they're wanting to argue it out. So we actually do have oral arguments set to be heard in mid-May. So that's just kind of how the system works, incredibly slow and in a particular way that makes it so you would think that would be the first thing you would get sorted out. But, we have to do everything the hard way. Yes, I've got my eyes glued to this particular issue on the Alien Enemies Act. Can the judge require a video call to assure he's alive? Well, yeah, the judge can do whatever she wants to do, but whether or not they'll get compliance from El Salvador is another question. If she told the government to set it up and the government didn't comply, then she could go after the government. But right now, she's not even getting basic information from the government. I mean, we've got a declaration saying he is alive. And that's about it. Yeah. So, it's a mess. All right, here we go, everybody. Last document for tonight. We can do a full Q&A here. Defendant's response. Oh, thanks, James. Oh, I appreciate that so much for the sticky notes. I tell you, everybody, I'm so grateful. What happens if the government gets held in contempt? People start going to jail. Yeah, people can be put in jail. And that's a real possibility in this situation and in the JGG case. I mean, these government attorneys and these various people that are not complying with judges' orders, I mean, this is it. Like, you either comply or you get put in jail. Held in contempt. Right. Well, they're asking for contempt right now. Who gets held accountable? Anybody that this order is directed to. So, for example, let's step back into the JGG case. Everybody, you know what I'm talking about with JGG, right? That's the one with the original filing regarding the 5 people. What the judge did in that situation was he asked the attorney, because he's going through right now to decide whether or not there's contempt. He asked the attorney, well, you heard it, right? Yes. And who did you tell? Well, I told these 3 people. Did anybody else know? I don't know. Well, are these the only names of the people? So right now the judge has a handful of people that he can say, you need to come in and explain to me that you didn't violate my order. And if you can't explain it, you go to jail. So he's already got the attorney on the hook. That attorney's already on the hook for violating the order. Now we have the other people the attorney told. All right. So that's how it goes. I mean, you can't just pull the whole government in. You have to pull the exact person in that knew and failed to comply with the order. And that's absolutely possible to do that. Judge isn't going for contempt. They are going for contempt. They are. It's just, it takes time. Contempt also takes a lot of time to do. Like we just had a filing yesterday asking for a full contempt hearing in this case, saying, and the judge already found a violation of her court order that they refused to comply. So she's already found one. Now the question is, what's going to be the accountability? And are we going to have another hearing in order to sort it all out so that we can have that accountability element? And the judge will have to take that in and decide whether or not to set it for a hearing or continue to go forward. Would it make more sense to find them? It's yes, and that's typically what's happened before, is you can find them, you can do all kinds of various other things, but fines tend to be the biggest, most frequently utilized. Jail is utilized when they just will not listen, because if you put an attorney in jail for 48 hours and then they get back out again, they may have a different perspective on things. Oh, absolutely, absolutely. Accountability is so important here. All right, let me dive in. This is the defendant's response, everyone. Let me take a drink here. All right, what happens if there are no attorneys left in the DOJ? Well, they're going to have to hire them quick. If attorneys miss deadlines, cases get tossed. So if they miss deadlines for these other criminal cases that have nothing to do with any of this baloney, then those cases, if you miss deadlines, the cases can be dismissed. Yeah. I'm not sure a pardon would cover contempt conduct in court. And that's oh my gosh, I tell you what, John, that's a really good question. It's not been tested. We have a lot of academic theories on it, because if we're talking about contempt in a civil manner, we're talking about something outside of pardonable behavior. But if we're talking about criminal contempt, which is, again, the loss of freedom, so any kind of jail time, that could rise to the level of being enough of a crime that would allow the president to pardon that contempt. But as you've seen before, we're in a tricky place because Congress, was probably one of the biggest places where you saw Congress going out and saying, well, they are in contempt of Congress, and then courts finding it and then them not not being, sorry, everybody, I just forgot the word. It just left my brain. Pardons. So we don't know. We don't know. We do not know what will happen. We are in a different world here. All right, defendant's response, plaintiff's motion for additional relief. Now, I'm interested to see, I don't need to read through all of this, but I'm interested to see what their initial response is here. What if they won't lie? Yeah, it's a good question. We just don't know. What if there's loss? Well, that's, again, suable situation. All right, here we go. On Friday, April 11th, the court found the defendants failed to comply with the court's order entered hours earlier. That's petty much. Directing defendants to submit sworn testimony revealing sensitive information and previewing non-final, unvetted diplomatic strategies. You know what's non-final? Whether or not they're actually part of this gang. That's non-final. Let's remember that. The court then ordered that beginning April 12th and continuing each day thereafter until further order of the court, defendant shall file daily a declaration made by an individual with personal knowledge as to any information regarding 1, the current physical location and custodial status of Garcia, 2, what steps, if any, defendants have taken to facilitate his immediate return to the United States, 3, what additional steps defendants will take and when to facilitate his return. In addition, the court set a deadline for plaintiffs to seek any additional relief by April 12th. In response, plaintiffs moved for 3 categories of relief. Number 1, an order superintending and micromanaging. Oh, come on. Oh my gosh. Defendants is foreign. I think this is Steve Miller again. Anytime I read a filing that's just absolute rubbish, I'm like, I think Steve Miller helped. Defendants foreign relations with the independent sovereign nation of El Salvador. 2, an order allowing expedited discovery and converting Tuesday's hearing into an evidentiary hearing. And 3, an order to show cause why defendants should not be held in contempt. All right. The court should deny plaintiff's request for further relief. The relief sought by plaintiffs is inconsistent with the Supreme Court's instruction requiring this court to respect the President's Article 2 authority to manage foreign policy. All right. The court should therefore reject plaintiff's request for further intrusive supervision of the executive's facilitation process beyond the daily status reports already ordered. Oh my gosh. Well, at least they didn't say to the judge, we're not doing your status reports, although technically they're really not. But all right, footnote number 1, defendants object to the request. All right, sorry. Spoke too soon, everybody. Spoke too soon. Oh my goodness. I have not read this, all right? Defendants object to the requirement of daily status reports and reserve the right to challenge that requirement further. I spoke too soon. All right. Plaintiffs' requested additional relief is not consistent with either the Supreme Court's order or the well-established meaning of, quote, facilitating returns in immigration law and harbors fundamental constitutional infirmities. This court should deny the motion and adhere to the best reading of its amended order. Now it's starting to sound like we've got a little bit of the AI going on here. On April 10th, the Supreme Court granted in part the government's motion to stay this court's original preliminary injunction order. The Supreme Court explained that on remand, any new order must clarify the scope of the term effectuate in a manner that did not exceed the district court's authority. The court instructed that any directive must give due regard for the deference owed to the executive branch in the conduct of foreign affairs, and it made clear that any directive should concern Garcia's release from custody in El Salvador and ensure his case is handled as it would have been had he not been improperly sent to El Salvador. In response, this court amended its prior order that evening to direct, apparently they're mad, that defendants take all available steps to facilitate the return of Garcia to the United States as soon as possible. Defendants understand facilitate to mean that term has long meant what that term has long meant in the immigration context, namely actions allowing an alien to enter the United States. Oh my God, these little jerks. So they're saying facilitate means what they can do for him to come back into the country, not out of El Salvador. Taking all available steps to facilitate the return of Garcia is thus best read as taking all available steps to remove any domestic obstacles that would otherwise impede the alien's ability to return here. Indeed, no other reading of facilitate is tenable or constitutional here. Wow, that's really awful. This reading follows directly from the Supreme Court's order holding any directive must give due regard to the executive branch's exclusive authorities for foreign affairs. It tracks long-standing executive practice here, ICE policy directive, that well-established policy of the United States, and it comports with how the federal courts have understood the outer bounds of their own power. Oh my gosh, this is just really awful. I'm at this moment, I have to think, did Thomas call somebody and say, so don't worry about bringing him out of El Salvador, focus on getting him into the United States? I'm wondering if Thomas was involved in that, because he would do something like that, because he's, not a good person. All right. On the flip side, reading facilitate as requiring something more than domestic measures would not only flout the Supreme Court's order, but also violate the separation of powers. The federal courts have no authority to direct the executive branch to conduct foreign relations in a particular way or engage with a foreign sovereign in a given manner. That is the exclusive power of the president as the sole organ of the federal government in the field of international relations. Wow, that's really awful, everybody. Such power is conclusive and preclusive and beyond the reach of federal courts' equitable authority. Plaintiffs' additional relief runs headlong through this constitutional limit. They ask this court to order defendants to, 1, make demands of the El Salvadoran government, 2, dispatch personnel onto the soil of an independent sovereign nation, and 3, send an aircraft into the airspace of a sovereign foreign nation to extract a citizen from that nation from its custody. All of those request orders involve interaction with a foreign sovereign and potential violations of that sovereignty. But as explained, a federal court cannot compel the executive branch to engage in any mandated act of diplomacy or incursion upon the sovereignty of another nation. Plaintiffs invite the court to exceed its own authority in the precise sort of way the Supreme Court cautioned against. This court should decline the invitation. Oh my gosh, this is just so awful. No additional relief is warranted at this time, consistent with the court's latest order. Defendants are providing daily status reports that share what they can as the government determines an appropriate course of action. Although defendants were not prepared to share information with the court within hours of its orders, defendant responded to the first of the court's questions yesterday evening, confirming Garcia was alive and secure in the custody of El Salvador at the center. It is now public information the president of El Salvador is currently in the United States and will be meeting with with Mr. Trump on Monday, April 14th. Politics chat, Trump to meet with whatever. Defendants will continue to share updates as appropriate. Any further intrusion into this sensitive process and any directive from the court to take action against the nation of El Salvador will be inconsistent with the care counseled by the Supreme Court. God, these people are such jerks. Yeah, there's no humanity. They're just complete monsters. As discussed above, the court should decline plaintiff's request as requested steps both exceed defendant's authority and are inconsistent with the Supreme Court's direction. The court could not and should not enter an order directing any of these steps. For many of the same reasons, the court should deny the expedited discovery request by plaintiffs. This discovery, including the presentation of live witnesses, would probe the executive's preliminary thinking on diplomatic efforts and would go well beyond requiring the executive to reveal what it can about the status of this process. That request is particularly inappropriate given such discovery could interfere with ongoing diplomatic discussions, particularly in the context of President whatever ongoing trip to the United States. In addition, plaintiffs' request for documents reflecting the terms of any agreement, arrangements, or understanding regarding the government's use of the facility to house U.S. deportees. Hold on, they're U.S. deportees, right? So own that. You just labeled them yourself. calls for the immediate production of classified documents, as well as documents the defendants may elect to assert are subject to the protection of attorney-client privilege and the state secrets privilege. It would be inappropriate for this court to hastily order production of these sensitive documents, particularly where defendants are continuing to regularly update the court here with no information that's of any use, but whatever. Finally, the court should not issue an order to show cause. Plaintiffs began their motion with a quote from the president confirming his respect for the Supreme Court and intention to comply with its order. Defendants remain in compliance with the Supreme Court's order based on the Supreme Court's order and respect for both the executive branch's authority over foreign affairs and the sovereignty of El Salvador. The court should take no further action in response to plaintiff's motion. They could say everything is, but that's the thing about it. You can say everything is classified, but classification can be overcome if you have permission or if you have proper what's the word I'm looking for, everybody? This has made me so upset that I just basic English has escaped my brain right now. I'm thinking in Mandarin at this point. What am I saying? Clearance. If you've got classification, if you've got classified clearance, you get to see it, and judges get to have that kind of clearance. Yeah, state secrets is what they're arguing in the JGG case. That's a pretty long shot, actually. I don't even know why they're bringing it up other than to just kind of stall it. Oh my gosh, it's so awful. This is so awful. Don't hurt your phone. It's expensive, and I'm not sure when we'll be able to get another phone, everybody. Oh, it's so awful. It's so awful. All right, so let's do a little bit of Q&A here, everyone. While my brain's still mostly working here. Can the Supreme Court order this whole El Salvador arrangement be shut down? They have to be asked that question. So that's the key to it. In order for the Supreme Court to do anything, somebody has to file a lawsuit. And right now, we do have lawsuits being filed saying this whole El Salvador situation needs to be shut down. We have three class actions situations going on, but one specifically regarding El Salvador and saying that it's not appropriate to put people who have been deported from the U.S. into El Salvador. So that is on its way to, thank you very much, Navy vet, that's right. It is on its way to the Supreme Court. Want to play both sides? I think they wanted to, I'm not sure. Justice Sotomayor, who didn't do a dissent, but she did a statement, and she said, we've got no business even reviewing this. So I think one of the reasons why anything came from it was to kind of assert the authority that they wanted to be able to say what they want regarding temporary restraining orders and preliminary injunctions. So it was a procedural question that the Supreme Court's like, we want to go ahead and be able to decide these issues instead of leaving it to the lower courts. So that was really what the issue was here. Amnesty International still a thing? Oh, that's a good question. I think so. I think it is. Let's see. The next step will be taken. This is all nuts. Yeah, every day it's going to be nuts. Every day it's going to be absolutely bonkers because this is the fight. These attorneys are coming in and saying to the judge, we're not going to tell you anything. We're not going to do anything. The only thing we have to do is make it so he can re-enter the United States. We don't have to make it so that he can leave the facility that he was put into. Meanwhile, the judge is like, I don't even know what the contract says. I don't even know what the agreement is between the U.S. and El Salvador because the government won't even share that information. So we don't know exactly what custody is with whom, or if it's temporary custody or independent contractor contracts going on. We don't know because the government won't give that information to the courts at the moment. What can the courts do? The courts will do what they have always done, which is they will, much like military tank style, they will keep moving forward and crush everything in their path. It's a slow process. If you think about a tank, it's slow. but one step at a time. In the JGG case, that judge is absolutely one step at a time building this situation to holding everyone accountable for not following the order. This judge will do the same. So it's a slow process, and unfortunately, a lot of harm can be done in the interim. But legally, what they do is they follow every single T and dot every single I and make sure everything is perfect, so that the next interlocutory appeal up to the Supreme Court is fully backed by precedent and information as well. I have no doubt this case will ping back up to the Supreme Court multiple times before he actually before he will be moved, if that does happen. Oh, it's awful. It's awful, the back and forth. I know there isn't any time, and that really that's really atrocious, right? I mean, who knows what's going to happen in the interim unless there's some kind of special protection, which of course the president of El Salvador could give some special protection. You know, I mean, he's here sitting around powwowing with, I apologize. That's not the term I meant to use. He's sitting around having some tea with Mr. Trump. You know, I mean, those guys can come to some understanding, but, you know, who knows what's really going to happen. Exactly, Isabel. That's the issue, right? That's the issue. So we don't know. And the courts will, again, like a tank, roll through every single piece of what is constitutional in order to make this happen. But it'll take a while. Why are they claiming the agreement's classified? Because it has this foreign relations element to it, which the president under Article 2 has a piece of. But see, they're saying he has a piece of foreign relations, not for the court, but every piece of the branch of government has a piece of foreign relations, right? Like the Supreme Court and lots of our courts hear cases from, involving other countries, involving other laws, and like, maritime law and all that kind of crap. So that's not true. And then Congress can make a whole bunch of agreements with foreign countries. And so that's just not true either. It's just each branch of the government deals with foreign relations in a different capacity. But it doesn't mean that they don't have any dealings, that it's only up to the president to work with other countries. It's just not true. Yeah, I agree. They don't want to know. Right. They don't want to have it. Yeah, and you can see it though, can't you? You can see how these, dumbasses kind of got together and was like, well, this guy Garcia's been on the roll for a long time. Why can't we get rid of him? And then someone's like, well, we've been trying, but they won't let us. So they're like, well, let's go ahead and put him on a plane. Just put him on a plane. We'll just apologize later, like hands off. We can't do anything about it. All right, let's put him on a plane. And so then they go and shove him on a plane, and off he goes to El Salvador. And they're like, well, I guess if it's a problem, we'll have to sort it out later, but who really cares? Courts can't do anything to us. And then it's like, boom, holy crap, you betcha we can. We're going to try. Iran-Contra, exactly, Beverly. That's where we're at again. Yes. Yeah, I mean, you will never be able to make this truly right. Right now, it's triage. We're trying to stop the blood, right? We're trying to stop the by getting him out of El Salvador. The exigency emergency situation is what they're trying to work on right now. But if that is even possible, then after that, we can start picking apart and seeing how much of a mess this actually was. The whole administration, well, that's exactly what they're doing. They're doing all of this stuff because they don't know what the H they're doing, right? As was shown by the Signal app. They're like, oh, look at us, we're really special people. Let's use this app because other people use it, blah, 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 blah. Like, come on, read the room, figure this stuff out, use what small brains that you have. And they struggled with it. And so there were problems and they got caught. And now they're just like, oh, well, this happened, blah, blah, blah. So that's what they're doing. I mean, that's exactly what they're doing, because it's a whole bunch of, frat boys hanging out, trying to run the country for funsies. So, yeah, I'm not holding my opinion back on that. Can you imagine? Oh, I know. I'm trying not to. Linda. That's definitely an issue. People out there Yeah, they get people out of places all over the place, right? I mean, this is ridiculous. This like I was in this situation, this Garcia, this JGG situation, this is so atrociously horrible. This is such a huge black mark, or is this is putting red in the ledger, if you will. It's so atrocious. She sells their tie and rub aside. I know. I know. They're like, where's the couch? Is a wife and children. I know, right? Provide proof of life. She can. She can. Whether or not they will do that is another question. Because they can say, well, we're not going to. And so then she can say, fine, we'll have a show cause hearing while you're violating my order. And then we have to brief it. And then we have to have the hearing. And then if the hearing doesn't decide anything, then we have to have another hearing with witnesses called in. And then we have to have, after briefs done. And then the judge has to sit and think about how she wants to word it. Don't get me wrong, this judge understands the exigency of this situation, but the government attorneys here are going to be total and complete jerk faces the whole time. They know exactly what they're doing, and they're doing it unapologetically. They don't expect to get into trouble. They've already... Exactly right, John. Exactly. They're like, we can walk away. There's no criminal charges. You can come for us because we'll just get a pardon, Get the puppet out, write some pardons. Woohoo, it's puppet time. I mean, I can't even help it anymore, everyone. This case is so awful. I may have started to crack a little because of how awful this case is. And it's not just this one either, everyone. And I try to stay positive, but we have so many habeas cases going right now. We have like 6 habeas cases involving El Salvador, and then we have a handful of cases, people getting picked up off of the street and put into the jails. I mean, are you freaking kidding me? We're only here. This is only 50%. This is the one that's bleeding out the most, but we still have Miss Chung, Miss Ozturk, Mr. Cahill. We still have these cases running of these other people pulled up off the street. So yeah, I mean, it's ongoing. It's every day something different's happening. Some kind of BS is happening. Like, we can't get Cahill back from Louisiana into New Jersey, and Ozturk's like, dude, I can't breathe, I have asthma, where's my medicine? And they're like, you're not getting any medicine. I mean, it's awful. Well, yeah, I mean, it is what it is. It is what it is. Facts are facts, and this is pretty bad. Yeah, it's pretty bad. It's pretty bad. Yeah, that's true. And again, we're supposed to have due process. I mean, that's just basic understandings. And these ICE people, like, I've trained a lot of cops. I've trained a lot of law enforcement. And I tell you, I mean, it starts at the top. So if they're working for leaders that are like, we don't care about the rules, they're not going to care about the rules. And that's just really unfortunate. 2 weeks, right? Yes. And that's going to continue. That's going to continue. My mother-in-law, who's been in the country and is a citizen now, is like scared, of course, to even travel to other states, which is understandable. Absolutely understandable. And, that's one of the things that people are saying, oh, I've got the right to travel from place to place. It's a privilege and an immunity. You have a privilege to travel around, and that's being hindered right now. Inspire me. Well, yeah, you got to keep going. I mean, that's the thing, everybody. I mean, we're going to go in waves here. We're going to go in waves. One day it's going to be like, you people need to get your stuff together. And then the next day it's going to be like, okay, I just need a sheet mask and I need like ice cream. And then the next day it's going to be like, and I'm back again. Listen what I got to say to you. And then the next day it's like, just give me the chocolate and don't talk to me. That's what it is. It's just an up and down. We're a roller coaster, and we just, peak and valley at different times. And that's, teamwork there. Teamwork making the dream work here. Yeah, next week's going to be very telling, Navy vet. Next week's going to be very telling. We'll see what order comes out tomorrow regarding whether or not we're going to do a contempt hearing, and then whether or not she will turn that Tuesday hearing into an evidentiary hearing. We'll see that. We will also be seeing more declarations, probably useless, but declarations nevertheless coming. So this week's going to be a very busy week for the Garcia case. SCOTUS rulings that elaborate on pardon power. Says they're absolute with one exception in the event of impeachment. Right, right. Trump is still under it. No. So no. So the pardon power is one that they referred to in the Trump case from last summer with immunity, because it's so clearly set out in the Constitution that it's obviously one of the powers set out for the president. So the pardon power is pretty much the only one that we can look at and say for sure that that is official conduct. That's his official duty. So that's why they use that as an example. Justification for pulling student visas. Nobody knows at this point. What's been filed in the cases is because of protesting. It looks like, from what I've read, all of them were involved in different protests involving Palestine. That's what I have read. So they're habeas / First Amendment cases. Gluten-free Oreos. No! Oh my gosh, you gotta watch that. Even the gluten-free. Anything, too much of anything's not good. But yeah, I understand. I understand. I've been making about 2 batches of Rice Krispie treats a day, everybody. Now, don't get me wrong, I'm not eating them, but we have someone in my family who has a low iron. She's got a deficiency. She's anemic. And so the only thing I can do right now is I'm like, the whole world is on fire, so I'm going to make more iron supplements for this person. So I make up so much, and so my fella's like, can you stop? Can you stop with the Rice Krispies? Do you need to get the Sam's Club size marshmallows and Krispies? I'm like, just stop asking questions. We're all doing what we have to, right? We gotta survive. Oh, yes. Oh, I love the fluff. You can do it both. You can do it both ways. See, the Rice Krispies have the highest iron level. That's why we do it. Pull the status and report. That's possible. It's absolutely possible. Military tribunal. Well, yeesh. I just don't know at this point. Yeah, Marco, again, I think it's because he's on a leash, and that, can be jerked anytime. And so I think if he tries to use his own sense of what's right and wrong, he has a negative sanction. So I think power absolutely corrupts people, and I think that's absolutely what we're talking about. Yes, the Rice Krispie treats help the iron. Yes. I mean, it's 60% of your daily amount of iron per 1.5 cups. And then if you put melted marshmallow cream in it, it's like, come on, iron supplements, man. That's what I'm saying. Chips Ahoy, really? All right. Ooh, chocolate peanut butter. Oh my gosh, yes, everybody. Marshmallow fluff. Oh my gosh, that's crazy. Homemade? Wow, that's crazy. I know. Go and look. And I tell you, there's somebody in my house, and it's not me, that eats total and just goes around and saying, you'd have to have 7 boxes of this in order to equal 1 bowl of my total cereal. That's like what he says all day, every day. But my kid doesn't like total, so she's getting Rice Krispies. Oh my gosh, everybody. We're all cracking up here. We're all cracking up. Yes, the marshmallow fluff. Yes. I'm going to definitely. Oh my goodness. Yep, we're losing it. I'm losing it, everybody. Oh my gosh. So, yes, this whole situation is just absolutely horrific, everybody. So I laugh because I can't cry. I will keep everybody posted on what's going on, though. I am posting as quick as I can over on the talk. Again, I'm only going to be over on the talk, for a few more weeks because it's going down. So my first priority, of course, is the YouTube. Some of my longer posts, though, just don't get put into the algorithm. But I'll keep you posted on this. I will have an update every single day, and it'll be in my shorts over here That doesn't sound right. It'll be in YouTube Shorts over here what the latest filing is. So if you're wondering, I'll keep you posted on it. If we have any like breaking orders, those will be over on TikTok. Unless it's a Tuesday or Thursday, we'll have to see how things go. Oh my gosh. But with that, my friends, I better let you go. This is all being recorded and I'm going down here in a blaze of glory. So I should let you all go. Have a great night, everyone. I'll see you all again very soon. Tuesday, Thursday, Sunday. I'm still trying for that. That's my goal. So that's still my goal. We'll keep working on it. Have a good one. Thanks for coming and hanging out. I really appreciate it, everyone. And I will see you all again very, very soon.